Why should property owners be held to ransom by private liquidators? Who regulates the conduct and cutthroat behavior? Why are the related government agencies keeping deafening silent over the ill conduct? Abu Qasim has been staying at the condominium for 12 years, diligently paying his dues. Unfortunately, the housing developer suddenly wound up. At the material time, all the strata titles have been issued by the land office and were in the possession of the then defunct developer. As a normal regulation, a liquidator was appointed to take custody of the development. As part of his duty in performing the functions of a developer, the liquidator was to arrange for the owner's collection of strata titles. To the later consternation meaning a feel of anxiety and dismay, the liquidators arbitrarily imposed charges of 2% of the original purchase price or the sales price in a subsale, whichever is higher. Abu Qasim was shocked by the double jeopardy, especially when he had paid the entire purchase price to his developer. He couldn't afford to pay the liquidator's demanded fees on top of the requisite stamp duties. He was left in a dilemma as the liquidator imposed a deadline to collect the titles, failing which the latter threatened to auction the unclaimed units.
What the what?
Now, the above scenario happens quite often in situations involving defunct property developers. These complaints are not something new to the Malaysian Department of Insolvency, MDI, and the National Housing Department under the auspices of the Ministry of Housing and Local Government. Now, delivering a project on time in a satisfactory manner is the primary duty of a developer. In addition, the developer must also procure the issuance of individual titles and subsequently assist in transferring the title to the purchaser. However, things can get complicated when a developer is compulsorily wound up pursuant to a court order, or mostly due to inability to pay debts, before the individual titles have been issued and transferred to the rightful purchaser. Now, in the absence of an individual title, and as a matter of procedure, a purchaser will have to obtain written consent from the developer before the property can be assigned to another owner. Now, the unhealthy practice of liquidator imposing exorbitant administration fee of up to 2% or 3% of the purchase price, or in some cases current market value of the property, for executing the memorandum of transfer of individual title to the purchaser has now become a norm. The fees is purportedly used to cover the liquidator's cost in retrieving the related documents, which have been purportedly destroyed or misplaced by the developer, and verifying the same with the purchase proof provided by the purchasers. Consequently, a straightforward perfection of transfer becomes a costly affair.
I have no money.
Unilateral imposition of such fees by liquidators are devoid of any legal basis. Furthermore, the sum imposed is ridiculously high and is far more than enough to cover reasonable administrative costs involved. This casts doubt on the motive of collecting such fees and raises the question of whether the liquidators are unjustly enriching themselves at the expense of the bona fide purchaser, who are already in a precarious position without the individual title. Let me talk about liquidators being bare trustee. Now, it is an established principle of law that upon full payment by purchaser, a developer becomes a bare trustee of the property. In other words, once the developer has received the full purchase price for property, the developer is no longer the real owner of the property. The developer is merely holding the same property in trust for the benefit of the purchaser. The developer, as a bare trustee, has no beneficial interest in the property anymore. It follows that a developer cannot deal with or treat the property as belonging to itself. Once a liquidator is appointed, he steps into the developer's shoe. It follows that the liquidator assumes the same role as a bare trustee and is not entitled to any benefits more than the developer. Similarly, a liquidator is not authorized to deal with a property other than to transfer the property to the rightful purchaser. Pending transfer of the title to the purchaser, the liquidator is acting as an interim caretaker to the sold property. So, as a bare trustee, the liquidator is not allowed to profit himself using the trust property. Now, one of the fundamental amendments to the Housing Development Control and Licensing Act 1966, call it Act 118 or HDA, which took effect on the 1st of June 2015, namely Section 3 of the interpretation, extended the definition of housing developer to include a person or body appointed by the court of competent jurisdiction to be the provisional liquidator or liquidator for the housing developer. Now, the amendment to include a liquidator as a housing developer was intended to fill the void when the developer is wound up before completion of its duties, obligation under Act 118. The duties include to complete construction of a building or facility, deliver vacant possession, and apply for individual strata title, thus not leaving the purchaser in the lurch. As a result of the said amendment, a liquidator will be subjected to the duties and responsibility imposed by the Housing Development Act HDA and may be liable for breaches of a de facto housing developer. Or rather, hence, a liquidator should not be allowed to charge or impose any additional administrative fees when carrying out his duty, since he is assuming the affairs and responsibility of a defunct developer contracted in the sale and purchase agreement. SPA, adopting the statutory form set out by the Housing Development Regulation 1989, have been consistently regarded by the courts of law as having the effect of statutory provision. The agreement provides that it is the developer's duty to execute the transfer document upon issuance of individual title in favor of the purchaser. By collecting administration fees above and beyond the cap set out in the Housing Development Act, the liquidators are effectively seeking a fee to perform something which they are required under law to perform anyway. Why should the purchaser be held to ransom? Liquidators are appointed by the court to manage affairs or wound up companies as far as is necessary to realize the company's assets and pay up creditors. As such, they are considered as performing their duties on behalf of the court and are viewed as officers of the court. In addition, as a bare trustee, a liquidator is expected to diligently carry out the duty to verify the purchaser's record whenever required to do so, and should not be allowed to gain profit other than those expressly allowed by the court when discharging the duty imposed upon him as an officer of the court. While liquidators should rightfully be reasonably remunerated for carrying out their duties, their gain are supposed to be from the sale and realizing of the defunct company's assets, including from the unsold stock in the housing project. If there's no money to make for this process, then the liquidators have the right to decline the appointment in the first place. If at all the liquidators are allowed to collect administration fees, the fee should be kept at a reasonable level for the purpose of covering the liquidator's expenses in retrieving and verifying the purchaser's record of a housing project. Any attempts to seek additional profit beyond what is statutorily allowed should be stopped. Liquidators must not be allowed to hold the purchasers to ransom. After all, individual and strata titles are not assets per se. They are purchasers' ownership papers. There are several questions on my laptop screen, but I shall take two of the best questions. Dr. Cheng, I'm a victim of a housing project where a private liquidator has been appointed after the developer company was defunct. Their name is XXX. Looks like obscenity. The private liquidators demanded for 2% of the current market value of my property, and that's a hefty 16,000 ringgit for the so-called vetting fees. Which department regulates private liquidators, and whom should I lodge my official complaint to? Now, all private liquidators are licensed by Jabatan Accountant Negara, that's Accountant General of Malaysia, based at the Ministry of Finance. The license to practice is issued pursuant to Section 433(4) of the Companies Act 2016. Let me reiterate. extended the definition of housing developer to include a person or body appointed by the court of competent jurisdiction to be the provisional liquidator or liquidator for the housing developer. Hence, I term them as de facto developers, supposedly under the watchful eyes of Jabatan Perumahan Negara, JPN. Now, JPN is a department under the Ministry of Housing and Local Government, and they are the guardian of the Housing Development Act, HDA, vis-a-vis licensing, monitoring, supervision, policing, and enforcement. The Malaysian Department of Insolvency, MDI, is a federal agency that supervises insolvency management and insolvency affairs of private liquidators too. Perhaps the complainant could galvanize all the affected victims together with a view to lodge an official complaint to all the three agencies. Let's hope they will act on the complaints. Dealing with government department, you need to exercise perseverance. Alright. Second question, Dr. Chang, what would you think is a reasonable sum to be charged by private liquidators in a situation where we wish to collect our strata title, where our developer have been wound up by the court? Now, the issue of exploitative liquidators is not something new. Hence, the title of today's talk is Be Wary of Private Liquidators Making Fortune from Home Buyers' Misfortune. Now, in my opinion, a fair and reasonable sum is in fact 500 ringgit instead of 2%, 3% based on market value. The issue of administration fees has been decided in past court cases where the court of law has ruled that a fair and reasonable amount is RM 500. But yet, private liquidators refuses to abide by it, challenges the victim house buyers to take the case to court with the excuse that the ruling of 500 ringgit was distinctly for that case alone. The National House Buyers Association, HBA, has time and again reminded the Minister of Housing and those under the ministry charge to rein in the conduct of those so-called court-appointed officers, namely liquidators. JPN, Jabatan Perumahan Negara, has assured HBA that a new set of regulations will be formulated to cover the scope, role, remuneration scale. The aim is to regulate the conduct of liquidators and judicial managers with an emphasis on curbing dysfunctional acts, penalties for non-compliance, investigation, inquiries, and criminal prosecution, among others. Now, this regulation should be expeditiously formulated and enforced to prevent purchasers and owners from being affected by irresponsible liquidators. I hope I have answered your question sufficiently. Thank you for the excellent question. My next talk will be titled Be Careful of Superficial Discount That Mud the Property Market. The open secret that housing developers artificially inflate property prices and then offer a rebate to offset against the 10% down payment, thus indirectly giving their buyers up to 100% and financing loan. Now see you in the next episode.